Land acquisition. Ready? Start. The petitioners contended that the findings of this court in the judgment and order dated 10/5/1996 regarding the element of compensation are ex facie incorrect, and the said judgment and order is liable to be reviewed. It was urged that the increased FAR mentioned in the order is illusory and that there were restrictions on the permitted height of construction, and many of the owners of freehold land had not been able to use the increased FAR. They contended that if any land is required for the purpose of development or for any other purpose, DDA should resort to compulsory acquisition under Section 15 of the Delhi Development Act 1957. It was contended that no land can be taken over or required to be surrendered without compulsory acquisition under Section 15 of the Delhi Development Act 1957 and payment of market value as compensation. It was further contended that the mere fact that this court did not want the government to undertake the time consuming process of acquisition under Section 15 of the Delhi Development Act would not in any way detract from the rule of law which requires the land owners of Delhi industries to be treated on par with owners of land in other parts of the country which are acquired for the purposes of urban development. It was submitted while Section 15 deals with compulsory acquisition of land where the land is required for the purpose of development or any other purpose under the DD Act. Section 55 of the said Act deal with modification of the master plan or zonal development plan in certain cases. The said section provided that where any land is required by the master plan or a zonal development plan to be kept as an open space or unbuilt upon or is designated in any such plan as subject to compulsory acquisition, then if at the expiration of 10 years from the date of operation of the plan under Section 11 or where such land has been so required or designated by any amendment of such plan, from the date of operation of such amendment the land is not compulsorily acquired, the owner of the land may serve notice on the government requiring his interest in the land to be so acquired, and if the government fails to acquire the land within a period of 6 months from the date of the said notice, the master plan or the zonal development plan shall have effect. The learned amicus curiae pointed out that despite the fact that the master plan for Delhi was published as early as in 1990, these large and heavy industries did not take steps to shift their premises out of Delhi, and these industries had been causing severe pollution for a long period, thereby violating the master plan as well as damaging the environment. And it was at this juncture that this court had passed the order and directed all these industries to be relocated outside Delhi and issued categorical directions regarding surrender of portions of the land. Stop.